Everybody, I'm Vince White, and I am an employment attorney. But today we're not talking about employment law. We're talking about ERISA law, which is something I do not understand at all. And it's very frustrating because it comes up in my field more often than I'd like to admit. It's not what we do, but it comes up. And the gentleman I used to refer to 4 years ago retired, and I couldn't find anyone until I found attorney Jason Newfield. How are you?
Good afternoon. Thanks so much for having me. I appreciate the opportunity. Jason Newfield from Newfield Law Group in Melville, New York, and I help people with ERISA cases throughout the country. Thanks so much for having me.
So listen, I'm gonna sound ignorant because I am. Can you explain to us what is the field of ERISA law?
Sure. Well, as it pertains to disability insurance anyway, because that's the narrow sphere that I typically work with. I don't deal with those other, we'll call them the umbrella of ERISA, but ERISA disability law, LTD, as we would call it, is part of a group benefit package. Typically, Fortune 1000 company employees will have, ranging from the CEO down to the executive assistant to anyone in between. And it'll typically provide a percentage of their salary. Oftentimes it's paid for by the employer. Sometimes there's a supplement that the employee may pay, and there's other factors that come in. But effectively, it replaces a portion of their salary if they're unable to work due to a sickness or an injury, and it'll last for a certain period of time. So there's short-term disability sometimes, and then there's long-term disability. My practice often focuses on the long-term disability benefits that are available, typically for people that are going to be out of work for some period of time that's significant, so that it'll be of value and there'll be a return on the investment that they're going to make in working with us. What do we do? We'll evaluate the policy, we'll evaluate the medical condition, evaluate the medical support, give them some guidance in terms of the process. In many cases, we will then navigate the claim on their behalf. We'll become the face of the claim. We will interface with the insurance company. This is what we do all day, every day. It's what the insurance company does all day, every day. It's what an insured does for the one and only time in their life. So they are at a disadvantage. We try and level that playing field. We try and put them in a better position to navigate this claim. We guide them through this process. We let them understand what their rights are. We also let them know what their obligations are, their proof of loss obligations, what it means to show how and why somebody is disabled, and what those policy terms are.
Amazing. And I love to echo what you said in there because it's something we stress on the channel. People will come on the channel and they'll be like, oh, you're wrong. My case is worth 30 million. I know it. And you kind of raised the issue of repetitions, reps. You've had more contact. You've done this many times, right? If you've done something successfully thousands or hundreds of times or tens of thousands of times, you're going to know a lot more about it. And that's something I try to stress to the viewers is they'll come in and say, listen, you seem like a nice guy, Vince, but my case is worth 30 million. I know you might not think so, but I know. Great. That is based on your deep well of knowledge and experience from never having done this before, right? So I want to stress that level of experience that he speaks to there, tremendous value. Like that, you can't, I mean, I want to say you can't buy that. He can't buy that. He built that. But you listen, you pay the right person. I suppose you can buy it, right? You can buy the benefit of it at least, right?
Sure.
So, okay,
And
the
some of that's through the School of Hard Knocks, and more of that's from learning. Every day I get decisions sent to me from our subscription services, and you learn from other people's losses and yours as much as from those wins.
yeah,
What it was about the case that the judge didn't seem to want. So how do you modify your practice? How do you improve and enhance for your next client based upon those issues? And that's a daily basis. That's an evolution every single day from
yeah.
different courts throughout the country. Because even though it's a federal statute, each circuit will look at these situations with different nuances. And so it's important to not just be myopic and say, all right, that's how it is, because it may be different in Ohio than it is in California, than it is in New York, than it is in Florida.
Yeah, that is a great point. And that continuing dedication, that continuing flexibility and learning process, that's so important to any firm really fighting cases because the law changes, the jurisdictions are different, the case law shifts. You can't just say this is how it is any more than a doctor could say, oh, I know how to do blah, blah, blah procedure. Well, that was 30 years ago, right? And in our field, frankly, it moves, things move a little bit faster, right? In the past 2 years in employment law, we've decided that non-disclosure agreements, they ought to be illegal. And some federal agencies decided they were, and then they weren't again. And then maybe they are. And we don't really know today, right? And that's what he's speaking to, right? That's he's staying on the bleeding edge of his industry. Incredibly important. So someone thinks they might be an ERISA claimant. They think they might be a good client for you. How can they confirm or deny before they reach out to you?
Well, they can reach out to me for no cost. I'm happy to give a consultation. So I guess err on the side of consulting so that I can spot those issues rather than you call me later and have me fix your problem. But as a general proposition, anybody who has the group LTD policy should access that policy so that somebody like me can understand it for them. And there's a difference between what's called a summary plan document, which is an overview, and what is the certificate of coverage or the meat and bones. And so someone will tell me I have the policy and they'll send it to me and I'll say that's not. That is an overview of what it is, but that doesn't get us where we need to be in understanding those nuances. And I could spend hours talking about certain nuances, but there are certain critical ones. And sometimes there are limited benefit periods that in these policies that might relate to whether someone's mental health issues are the driving force of the claim or just a part of the claim, and or whether or not as a result of that it limits their benefits. And unfortunately, we still allow insurance companies to discriminate between mental health and physical health. And whether that's their fault or their or our problem is not the issue for today. The issue is that these policies exist and we have to navigate that. So one of the important things that I will do is in evaluating that coverage in those situations is explain how we might be able to go beyond that 2-year period for them under proper circumstances, or at least be, sometimes I say I'm a radiologist, I'm just reading the x-ray. I'm telling you what exists. This is it, right? And then I can maybe be your advocate, but I'm first going to be the radiologist and read it.
It's funny to hear that you share the same frustration we have with the mental health disabilities versus physical disabilities in different ways, I'm sure, but it's tough for us. Juries, judges can be a little predisposed against mental health disabilities and accommodations. Um, we hear the classic, how could I, how could I expect this employer to accommodate somebody with a bipolar condition? Just and this is this hypothetical judge saying this, not me, never me. I would never say this, but just losing his or her mind on people every day. Hold on, that's not what a bipolar condition is. But also, that's not. No one would want that to be accommodated. That's you can't. That's that's an insane stance to take. It's not that, right? And I think part of our job is to educate, right, in terms of mental health disabilities. Like, hey, that's not what a bipolar condition is. And listen, there's a spectrum of how badly you might be suffering from bipolar condition. And listen, some people might be experiencing that. That could be really hard. Maybe that can't be accommodated. But if it can't be accommodated, guess what? It might be something that could receive benefits. Would that be a good individual to call you?
Yeah, so that's an interesting nuance where there are times where we may have that overlay where somebody has to, or potentially can have both claims, but may have to choose between a claim where they're able to work and can't be accommodated, or they can't be accommodated and can't work and they go down the disability path. So there are situations like that. And we also have those unfortunate situations that involve both of us where there's the harassment issues in the environment which cause mental health struggles, which we've seen a lot of, unfortunately, still existing. And in those situations, the insurance companies can be very difficult too, because they may interpret their policy as saying, we'll just use it as claimant A rather than get involved in anything specific.
Yeah.
Claimant A, you can't work at employer B, but that doesn't mean you can't do the job that you do at employer B, just not for employer B. Therefore, you're not even disabled. And so their view is, well, if we extricated that bad apple that was in employer B, you could probably return there, but that's unfeasible. So we're just going to say you're not disabled because you could go work for employer C. And so navigating those issues and having the pervasiveness of that impairment span not just employer B, but all employers is important and one of the roles that we may play when we're involved in helping these people.
Yeah, well said. And we see that a lot. We'll see somebody with a mental health disability or, sometimes a physical disability. And what goes on in the workplace is so ugly and so horrific that the condition can actually worsen as a result. And the client comes to me and says, "Hey, I'm getting worse. I don't, the condition's getting worse. I'm treating with a mental health professional. We have concerns." And then it becomes a question of like, well, okay, if it got worse, maybe the accommodation's not viable anymore. Maybe our case up till now is what it is. And you need to go talk to Attorney Newfield about benefits because you can no longer be accommodated, right? And it's a transition where our case continues to run because that person has, without question, been wronged. They've been harmed, right? I used to work for a guy who would scream, "He's been harmed!" Crazy person, um, but in that case, it doesn't get extinguished; it still exists. But there's also a future to think about, and those
Sure.
benefits can help with that.
So the only fear that I have for those clients, and this is again education, is you and your colleagues have to always make sure that the release, if any, that you have your clients sign, carves out the ability for them to still pursue their disability claim and their insurance company. Because I had a client come to me once without telling me she had signed that release. We
Ooh.
ended up litigating our case, and many years. Um, Depositions in Pittsburgh in -8-degree weather, although good experience. And the judge, rather than decide the main case, punted it on the release and saying, well, she signed the release with her employer, and she had some other lawyer at the time, and it was knowing and consensual, and it was broad and all these bad things when she had no intention to release the insurance company from a disability claim. And so the judge took the easy path and we were left out. We learned a valuable lesson. Anyone who's coming to you, make sure they haven't signed their release to a severance agreement. We work with employment attorneys all the time to educate them, make sure that the employment severance agreement has the carve out for our clients. It's very important. The last thing you want to do is extinguish those rights.
Amazing. And you work with the employment attorneys. So they come to you, they have a proposed settlement agreement with proposed releases. You'll take a quick look. You'll propose language for the carve out.
Absolutely. I'll say this is something that we need to have. This has worked before. And typically it's neutral to the employer, so they shouldn't have a problem with it.
Fantastic. And everybody, I want to stress this is not a paid spot. Attorney Newfield, I think, can really help a lot of people on this channel. I see these questions filter in the comments every week. I can't answer them. It's not what I do. And I know that's not your job to know that, but I can't. I just don't have the answers. I'm not going to go dip my toe in a pond where it's as likely as not that I'm wrong. Right. So I'm excited to have him here. I'm going to have all of his contact information down below. This is for you. This is someone who I think could answer some of your questions, who could help. I think it's really important. This is not paid. There's nothing of the sort going on here. All right. Um, Anything you want to add before we close up shop for the day?
I really want to thank you. We talked, I said educating people about the importance of getting us involved early in the process is so critical. I have people call me every day to say, their letter speaks to the fact that you can get a lawyer at the end, and it almost misleads people. And I don't want to speak to the fact that that might be intentional, but I feel as if most people are more naive than less. And so I want people to understand that they should avail themselves of rights earlier than later, free consultations, just knowledge is power. So avail yourself of it. And I thank you greatly for allowing me the opportunity to talk to people and educate them.
No, please. Thank you for gracing the channel with your presence. I think you're going to help people. Everybody, Attorney Newfield's contact information down below in the doobie doo. I think this is super helpful. I mean, it's not me helping, it's him helping, frankly. But that being said, if it was helpful, like, subscribe, comment down below, share the channel so it can grow. I think this is good. I'm excited for this. If you ever want to come back on the channel, super excited. You can teach us all some things, I can tell.
Great. I appreciate it so much. Have a great day.
Take care, everybody.
Be
Bye.
well.